Hello, good morning, good afternoon, good evening. I hope you're all doing well from a somewhat stuffy and humid northern England. It does look like rain. It's been warm all day. It's still very warm, but it looks like rain. So it's very dark. Anyway, hope you're all well. Hope you're all enjoying or not the summer or winter, because I do have a lot of people who watch my channel from down under. So it's going to be like midwinter for you, isn't it? Anyhow, Kohberger, Bryan Kohberger. Over the last couple of days, Judge Hippler has issued a couple of orders. The shorter one, the 7-pager, I read in a recorded video this morning. And at the beginning of that video, I asked people to tell me in the comments whether you're still interested in Kohberger. The reason I ask is because my audience demographic over the last few months has changed somewhat. So I'm not sure how many of the original people who were here when I covered Kohberger a lot, you know, in the early days of the case, I covered Kohberger a lot. And I'm not sure how many of those people are still here. And given that my audience demographic has changed, I thought I'll ask. And I think just about everybody who replied said, yeah, I'm still interested in Kohberger. But then again, it's a skewed opinion because the people not interested in Kohberger just wouldn't have clicked on the video to begin with. So it's a skewed thing. Also, I asked about Barry Morphew. Barry Morphew has been indicted for a second time. He's in custody for a second time for the murder of Suzanne Morphew. I asked about Barry as well, because I will be following that case up to trial and, you know, all the pre-trial stuff and whatever. And there's been lots of twists and turns in that case. It's a very fascinating case. And I think a few people said that you're following Barry, but not Kohberger. But most people who replied said that they're following Kohberger. So I'm here to go through the other order, the longer order, which is about the defence's motion to continue the trial. They want the trial continued. And Judge Hippler has said no. Judge Hippler has said, no, the trial goes ahead. And that's that. I knew he would. I really don't think Judge Hippler is going to entertain any of the defense arguments as to why they need yet another continuance. You've got to remember, though, that this case is nearly 3 years old. So I'm glad that Judge Hippler has said this, because despite what the defense claim about, you know, discovery violations and this and that, they can't have their cake and eat it too, because in one breath they say that the discovery is vast and they've not had time to go through it all. And then the other breath, they say that there's this that they've not got from the state and this that they've not got from the state. And they've been complaining for almost 3 years. I know it's only 2.5 years. It just feels like longer. They've been complaining all that time about the discovery. And the state has been giving them the discovery as they receive it. You know, because there's been the feds involved, there's been stuff that the state's not been able to get their hands on because the feds take their own sweet time. So there has been problems with discovery. That is a thing. That they're not lying. There has been problems with discovery, but they do have a whole lot of stuff, and the stuff that they've got, they've not even finished going through. So they can't have their cake and eat it too. They can't say we deserve a continuance because the state is being horrible to us, and then in the next breath say we've got too much work. But Judge Hippler is not going for it. The other judge, Judge John Judge, he was very quiet and he would basically continue. I think he would have continued. I think he would. Judge Hippler, though, is like, no, Not in this court. Nope. Oh, I run a very tight ship. So the defence are definitely not getting their own way with him. However, in my video this morning regarding the order on the alternate suspects, I think he's made a mistake, in my humble opinion, as a non-judge, as a non-lawyer, as just a third-party observer from another country. I think he's made a mistake in saying that the perpetrator arrived in a car, and none of the alternate suspects that the defence has named arrived or had a vehicle that looked like suspect vehicle 1. I think that's wrong. I think he has claimed that is a fact, and that's not a fact. It's for the jury to determine what is fact. The jury are the triers of fact. The judge is there to interpret the law and to make sure that everybody behaves themselves. He's not there to tell them the facts. So I think it's really wrong of him to say that, unless it's been stipulated by both parties that this is a fact and that they're going to say that to the jury, that both sides agree that is a fact and the jury must take it as fact. But no, they've not done that. We've not got to trial yet, so of course they've not done that. So, yeah, I didn't like that. Didn't like that at all. But in the main, I do like Judge Hippler. One of the reasons why I do like him is because when he denies something, he actually explains why. He gives a very full account of why he's doing what he's doing. And I like that. You know, having come from the Delphi trial, where you just got denied without hearing, at least Judge Hippler, he hears them. And he heard them on this issue. There was a hearing on June 18th. He did hear them on this issue. And he has given a 20-page, not 30-page. I think I said 30 page this morning. But no, it's 20 pages. So it's not going to take us that long to get through this. Member for 28 months. Who is this? Natilla the Hun. Member for 28 months. Thank you for being a long-term member, for being one of the OGs. One of the OGs. All right, this screen's got stuck again. It annoys me so much when it does this. All right, I'll just refresh it. That'll work. There we go. Okay, so I'm going to say a couple of hellos and then we're going to get straight into this. And I'll give my opinion as we go through. It's kind of interesting. But the spoiler alert, you know, the take home is that he denied the motion. So the trial is going ahead in August. Jury selection starts, I think it's the 4th of August. And then they're allowing 2 weeks for jury selection. And then the trial will start proper on August 18th. So we really don't have long. We really don't have long to wait. And this is going to be big. It's going to be a big trial. It's going to last for 3 months. And I think we're going to hear a lot. I think we're going to have some bombshells. I'll tell you one trial that I have been really looking forward to, which is on at the moment and is not being televised, is Brooks Houck from Kentucky. I've been looking forward to that trial, and unfortunately, it's not being televised, which is a shame. The murder of Crystal Rogers, whose body has never been found, but Brooks Houck, her boyfriend, is on trial for her murder. He did it. He absolutely did it. Okay, let's see who's in the house. We got CW's driving. We got Busy Baking Cakes. We got Jackie. We got Show Companion. We got Lisa. We got another Jackie. We got Jennifer. We got Geek. Geeking me out. Oh, geeking me out. I get it. It's when these things are all one word. It's difficult. We've got Cecile, Crystal. We got Shazza. We got Demos. We got TC. No more Kohberger news. Where are all the missing children? The missing children. There's many of them. There's many missing people. There's more missing adults than there are missing children. But I cover a lot of missing persons cases. Cover a lot of missing persons cases. I think probably the bulk of the videos I do are on missing persons of some shape or fashion. And then the live streams I do tend to be things like court proceedings and stuff like that. Not exclusively, though. I do missing persons cases in live streams as well. And we got Cheryl, Thriller. What else have we got? Steph. All right. Okay. Best friend's parents live in Bardstown. Oh, really? Bardstown is interesting place. Yeah, Lawyer Lee is there. She's in the courtroom and she's doing nightly recaps. You know, like we had in the Delphi case. Lawyer Lee is doing the nightly recaps. I've got a couple of nights to catch up on, actually. I watched the first one. So it's great. It's good that there is actually someone in the courtroom who's doing that, but it's not the same. It's not the same as being able to watch the trial yourself. It's not the same at all. Anyway, without further ado, let's get into this. All right, so this is the redacted memorandum, decision and order on the defendant's motion to continue. All right, okay. Before the court is defendant's motion to continue the trial in this matter. The basics for the motion is threefold. First, he asserts that the volume of discovery continues to pose a challenge to his counsel's ability to timely and meaningfully review all of it. Second, he asserts that there is a penalty phase investigation and preparation that still needs to be done. Third, he asserts that recent and forthcoming publicity on the case is highly prejudicial. Maintaining the current trial setting under these circumstances, he argues, will render any conviction and sentence unconstitutional. The state responds that defendant's motion is untimely and he has failed to show either good cause for continuing the trial or prejudice that would result from maintaining the current trial setting. Oral argument on this motion was held on June 18th, 2025, after which the court took the matter under advisement. The court finds a continuance is not warranted as defendant has not made a showing that there is good cause to continue the trial or that his substantial rights will be prejudiced by proceeding to trial as scheduled. And then we've got footnote 1, defendant filed some of his supporting materials ex parte. Okay. So that means that the defense provided some of the evidence in their motion to the judge only, so the state hasn't seen it. While the court is not convinced that much of his filing is necessary or appropriate to be treated as ex parte, the court will nevertheless, in an abundance of caution, issue a redacted and unredacted version of this order, with the state only receiving the redacted version, given that the court is denying the defendant's motion. So, interesting. I'd like to know what it was that they gave, but who knows? So, for 3 reasons, that the amount of discovery poses an issue. Now, look, there's a lot of discovery. There's a lot of discovery in this case, but even though, you know, there's like so many terabytes, a lot of it is irrelevant. A lot of it, apparently, is things like surveillance video, you know, because they collected surveillance video from literally all over Moscow and then parts of Washington state, So there's a lot of surveillance video, and because video files are huge, that's going to fill up a lot of the, you know, the terabytes that they're complaining about. But the vast majority of that surveillance video will be completely irrelevant. There'll be just nothing going on whatsoever. So somebody from the defense team needs to watch it, but they only need to focus their attentions on the bits where relevant things are happening. So they could have had a paralegal. They've had 2.5 years to do this, remember? They could have had a paralegal sitting there just watching it all, you know, on 10 times speed. And then when something comes into the frame, you know, some movement comes into frame, then they stop it and they actually watch it real time. And then if it's relevant, then they, you know, they clip that bit out. It's not rocket science. So a lot of these terabytes are that kind of thing. And because the defense has said they want everything, you know, they want the so-called irrelevant stuff. They've said that they want everything. Well, the state has supplied everything, and now they're complaining. So, you know, you can't win for losing here. And also, because there's a penalty phase, because this is a death penalty case, there's a penalty phase. So there's the guilt phase. So if he's convicted in the guilt phase, then it will go on to the penalty phase. So that penalty phase, the defense will be able to call witnesses, and the state will be able to call witnesses, and that will be a separate phase of the trial. Obviously, if he's found not guilty, that is irrelevant. But if he is found guilty, then it will go on to the penalty phase. And obviously, if it wasn't a death penalty case, then there wouldn't be that extra phase. So I think what the defense want to do ultimately is get the death penalty off the table. I think they want to shake the tree as hard as they can to see if they can get Judge Hippler to take the death penalty off the table. I don't think he will, but it's worth a try. And I don't, you know, although I do find the defense in this case somewhat annoying. I absolutely agree that they should be doing all of the things that they're doing. They should be shaking the tree. They should be trying their best to take the death penalty off the table, because they're working for their client. And he absolutely can't say that he didn't have a rigorous defense, because he has. And, you know, it's, if they were really, really overworked, they should have just employed some more paralegals. Like Judge Hippler, the last time they complained about this, said, you know, have you been to the, I've forgotten what they call it in Idaho, but there's basically a judge who is there, like not a trial judge, but a judge who is there, and a defense, like the public defenders, can go to this judge and ask for kind of more stuff. So they could have, I'm very sure, maybe got 1 or 2 more paralegals if they felt they needed it. So I'm not sure. I'm not convinced by their argument that they're overworked, honestly. And of course they're going to be busy, but I'm 2.5 years down the line, and they've tried this before. They've had various continuances before based on similar arguments, and I've never been convinced by any of them, to be honest. But here we are. And now Judge Hippler is saying no more. And then third, regarding the publicity, well, there's publicity. It's a huge case. If they continued it for another year, it wouldn't die down the publicity. There'd still be documentaries being made. There'd still be people writing books. I mean, the longer the time span, the more likely there is going to be more publicity. So it's not going to die down. It's going to get potentially worse. Like now, there's the Amazon Prime series that's coming out, which I'm going to be watching because I do have Amazon Prime, so I'm going to be watching that. You know, recently we had the Dateline and the leak, and now we've got Amazon Prime. And you can't stop that. Sorry, but in high-profile cases, you can't stop that. And the way to mitigate is to ensure that you get a jury who doesn't follow true crime. You get a jury who doesn't care about what's out in the documentaries in, you know, true crime, the true crime genre. They just don't watch it. And believe it or not, you know, we are biased. We think that everybody watches these kind of things, but no, it's because we watch them. But not everybody's into true crime. You know, I could walk down my street and let's pick the highest profile case in the UK. I could go down my street and say, you know, go knock on doors and say, how well do you know such a case? How well do you know such a case and such a case? And I'd probably get 50% who'd say, yeah, I know about it. Yeah, it's been in the paper. But they may not know a lot about it. I mean, there's all sorts of things that goes on in my country that I've no clue about because I don't watch the news from my country. It's just completely depressing. So I don't watch it. So anything that's going on in the news, if I was asked to be a juror on something going on in the news, I would be honestly say I have no idea what this is about. Anyhow, a motion for a continuance of trial is addressed to the sound discretion of the trial court. On discretionary matters, the trial court must 1, correctly perceive the issue as one of discretion, 2, act within the outer boundaries of that discretion, 3, act consistently with the legal standards applicable to the specific choice available to it, and 4, reach its decision by the exercise of reason. So this is Judge Hippler's analysis. And again, he's very wordy. I like this. Judge Gull should be taking notes from Judge Hippler. And this is how you write an order denying a motion. And remember, this has already been heard. This is already, you know, oral arguments have been heard at the last hearing, June 18th. So Judge Hippler has got, you know, the written motions plus he's heard oral arguments. So he can now give a solid yay or nay, which he's done. Under Idaho law, a criminal defendant seeking a continuance of trial must demonstrate that his or her substantial rights will be prejudiced, absence of continuance. And then we've got from State versus Cagle, 1995, unless an appellant shows his or her substantial rights are being prejudiced by reason of a denial of his or her motion for continuance, appellant courts can only conclude that there was no abuse of discretion. Trial judges necessarily require a great deal of latitude in scheduling trials. The burden of assembling the witnesses, lawyers, and jurors at the place and time of trial counsels against continuances except for compelling reasons. There are no mechanical tests for deciding when a denial of a continuance is so arbitrary as to violate due process. The answer must be found in the circumstances present in every case, particularly in the reasons presented to the trial judge at the time the request was denied. So that's what he's done. He's got written argument and he's heard oral arguments for it. So he's got everything he needs to make a decision. He's not cut any corners or anything like that. Where a continuance is sought based on the late disclosure of discovery of evidence, the alleged tardiness of the discovery must be shown to be so prejudiced the defendant's case preparation that a fair trial will be denied. The bare claim that additional investigation could have been conducted is not sufficient to demonstrate unfair prejudice so as to support a motion for a continuance. Additionally, where a continuance is sought for the potential receipt of evidence from further investigation, the motion is properly denied if based on speculation. So they can't come along and say, well, we might want to do further examination of this or that. You can't just come along and say, well, we might want to do this. That's just speculative. And they've had 2.5 years, you know, to do whatever further work they need to do, because they keep saying we've got this to do and this to do and this to do, but it's all based on speculation and we may get this and we may do this. And anyway, he's not going for it. Defendant argues the continuance is necessary for him to sufficiently review relevant discovery, conduct a full and complete investigation of mitigation evidence, particularly claimed newly revealed evidence that raises red flags and remedy the prejudice caused by recent and upcoming inflammatory publicity and the alleged leak of information to the media. So this is the alleged leak to Dateline. So we don't know who that leak is. I mean, look, Judge Hitler was fuming about it. You know, he was like, we need an investigation. We need a special prosecutor. I'm not sure how far that could go, especially if the leak came from the feds. I mean, we don't know where the leak came from. The leak could have come from anybody, from law enforcement to either of the defense or the state or the feds. It could have come from any number of people. So I'm not sure how far any investigation would go as to who leaked, you know, that surveillance footage and the pictures of Kohberger and various other things to Dateline. But yeah, he was fuming about it. Moving forward with trial, he warns, will violate his rights under the United States and Idaho constitutions to due process, to be free from cruel and unusual punishment, to a fair trial, to effective assistance of counsel, to present a defense and confront witnesses, and to a fair and reliable sentencing determination. Absent from defendant's materials, however, is any good cause for the continuance or legitimate showing of prejudice should the trial proceed as scheduled. You see, the thing is, Dateline has been and gone. The leak has happened. So if you want a continuance because there's adverse publicity, well, that adverse publicity has already happened. You can't turn back the clock. Yes, you can investigate how a leak happened, but that does not do anything to allay the possibility that some of the jury pool has been tainted by that publicity. The way to remedy it is not to continue the case for another year or whenever. It's to pick a jury that does not watch true crime stuff. That's your remedy. So it's not like there is no remedy here. There is. There's a very clear remedy. And that remedy is to choose an appropriate jury. Yes, you will have tainted some potential jurors who may have watched Dateline and then not seen anything else, but they've just watched that Dateline just off the chance. Yeah, possibly, potentially. But it doesn't mean to say, you look, the case has been moved from Latah County to Ada County in order to have that bigger jury pool and be further away from ground zero, so to speak. So they've done everything necessary so far to potentially mitigate for, Latah County being almost impossible to get a jury who has never heard of the case or who doesn't have an opinion of the case. Whereas in Ada County, it's much bigger catchment area, different demographic, and more likely to be able to get a jury who doesn't know about this case. They can have. It's not that they need to have never heard of it. The important thing is that they don't have an opinion on it, that they've not formed an opinion on it. So they've done everything they can. So continuing the trial because of publicity is not going to help. Who have we got here? Purple AJ, member for 44 months. Thank you so much. It will be good for this case to go to trial. It absolutely will. All right. Defendant has not demonstrated a continuance is warranted to review discovery. Defendant first contends that the vast amount of discovery in this case renders it impossible for the defence team to review the necessary and relevant discovery in a manner that allows it to be comprehensively integrated into his defence. He further argues, without any support or explanation, there is a myriad of issues that continue to arise from the state failing to comply with discovery and expert disclosure deadlines. Footnote 3. See order on defendant's motion to strike death penalty. The complaints are to strike. They really want the death penalty struck. That's what they're doing. They're shaking the tree for that reason. I believe personally, I believe. A continuance, he argues, is necessary for counsel to mount an effective defence. Paper chaser, member for 32 months. Yeah, if you want to avoid jury duty, watch Deadline. Yeah, absolutely. That's what you need to do. The court, however, rejected this same argument 2 months ago. He absolutely did. He absolutely did. They made this same argument 2 months ago. And they've made this same argument time and time and time again. They have. They've made it time and time and time again. And Judge allowed it because he was too nice. He allowed it. This case should already have been tried. It should have. Okay. So when defendants sought to strike the death penalty and impose discovery obligations upon the state, in its order, the court observed the utter lack of any proof supporting defendants' accusation of discovery violations by the state. More importantly, the court found defendants' complaints of being unable to meaningfully review discovery entirely unconvincing, pointing out that counsel struggled to articulate in any meaningful way what evidence, let alone relevant evidence, counsel had been unable to review over the past 2+ years, and why efforts to facilitate discovery review were not made long ago through this court and or the resource judge. The resource judge, that's what I was on about. So there is a judge that is there, and they can go to that judge. You know, it's not their trial judge. They can go and ask for further resources or go and argue the case about, you know, resources they need. So if they've not been to the resource judge and said, you know, we're swamped, you know, we need, let's say, 2 more paralegals to, you know, work on the surveillance stuff, they've not done that. So, you know, they've not tried to solve the problem themselves, which Judge kind of, I guess, I suppose, didn't look into, but Judge Hippler is much more strict. Stardust Shorty, member for 32 months. You are an OG, definitely. All right. Now let's have a look at these footnotes. The defendant specifically cites the 5th, 6th, 8th, and 14th Amendments to the US Constitution and Article 6, 7, 8, 13 of the Idaho Constitution. Notably, defendant does not argue that the Idaho Constitution provides any heightened protection that the... Okay, all right. Defendant's continual reference to the number of terabytes of discovery produced in this case is not helpful without providing a meaningful explanation of what data primarily consists of and its particular relevance and importance. Indeed, as was discussed at the April 9th, 2025 hearing in this case, I remember it well, it appears that most of those terabytes consist of extensive video surveillance from local businesses and residences that shows nothing of significance. As I said previously, a lot of these terabytes are surveillance video that somebody could sit and watch it all once, you know, on 10 times speed, and then just stop it when there's any movement to see if it's relevant. You know, because they did this vast canvas for surveillance, then, yeah, there's loads of it. And because the defense wanted it all, and they're entitled to it if they want it, they've been given it all, and now they're complaining. In fact, the state indicated at that hearing that much of that discovery is completely irrelevant and stipulated that it's unaware of any Brady material in the video surveillance footage other than specifically identified in motion practice. Given that the state has identified all its trial exhibits, the defense cannot be unaware. Where's this go then? Oh, God. Unaware of all the incriminating evidence in the discovery. Finally, it should be noted that it was defendants who early on demanded that the state provides. Yes, they did. I remember. They did. Exactly. They wanted it all. No matter how irrelevant or unhelpful. They did. They did. They did say that. Okay. Defendant's second round of this argument fares no better. He again fails to identify any relevant discovery that his counsel has yet to review. He also fails to identify any steps his counsel has taken, particularly since the court's prior order to aid in processing the yet unreviewed discovery. Moreover, he does not explain why he waited to seek a continuance until after discovery closed, expert disclosure deadlines passed, and the pre-trial conference occurred. If defence counsel was truly struggling with discovery review, this motion should have been made when the claimed problem became apparent, and certainly should have been brought prior to the expiration of discovery, all expert deadlines, and the final pre-trial conference. Instead, defence counsel has robustly litigated this case, retaining approximately 24 experts and the full mitigation team, engaging in extensive motion practice and disclosing witness and exhibits list with nary a whisper that a continuance would be sought. Well, they have applied for continuances before. They have continually complained about it, so they can legitimately come back and say, yeah, we have been complaining about this, because they have been complaining about this. These actions belie his counsel's ongoing and ultimately empty discovery complaints. He's so scathing with his words, so scathing. Without more, the court can only conclude that defence counsel is using the volume of discovery measured in terabytes as a tactic to delay the proceeding at the 11th hour simply for the sake of delay rather than a legitimate threat of prejudice to defendants' substantial rights. Perhaps even more problematic and more telling is the utter failure of defence counsel now and at any time to specify not only what needs to be reviewed, but importantly, when the review would be complete and the defendant ready for trial. Absolutely. You know, they've been complaining about all this stuff, done nothing to help themselves mitigate it or defend against it. And they've just been complaining, writing motions and just complaining instead of getting on with it or doing something about it. Let's have a look at these. The only discovery counsel claims have not been fully reviewed are all the thousands of tips provided to law enforcement. She argues these tips may lead to the discovery of evidence of an alternate perpetrator. The deadline for presenting alternate perpetrator evidence has come and gone, with no motion by the defence to extend it. Further, to offer alternate perpetrator evidence, defendant needs far more than an substantiated hearsay tip that another person could have committed the crime. Oh dear. At the hearing on defendant's motion to strike the death penalty based on his counsel's alleged inability to process discovery, the court suggested several options, and remember them well, that counsel had to obtain assistance in discovery review. There is no evidence that defence counsel has exercised any of these options, nor has there been any good explanation of why counsel has not sought additional resources to process and review discovery. Exactly. They've not helped themselves, such as the tips and security videos. The failure to do so suggests a recognition that this discovery is extremely unlikely to bear fruit. Relevant here too is the fact that defence counsel did not argue for a continuance as an alternate remedy to defendant's attempt to strike the death penalty because of counsel's alleged inability to get through the discovery. This highlights how his claims regarding the volume of discovery were used as a tactical sword, untethered to a seriously legitimate concern about the ability to be prepared. Instead, defendant seeks an unbounded continuance with no apparent plan to complete the review of unspecified evidence that counsel claims is yet to review. This is not sufficient to warrant a continuance. You see, if let's say he did a 3-month continuance, well, in 3 months' time, they'd come along and they'd say, oh, well, we've still not had a chance to review this discovery. We've still not done it. And then you get another 3-month continuance. Like, how long is too long? I mean, in my opinion, by the time this goes to trial, by the time the jury gets this case, it will be 3 years. Because if the jury's going to start, the trial's going to start on August 18th, and it's scheduled to run for 3 months, well, September, October, November, it's going to be mid-November by the time this trial reaches a conclusion. Well, the crimes occurred on November 13th, 2022. It's going to be 3 years by the time the jury gets to deliberate on this case. For the families, for the loved ones of Maddie, Ethan, Xana, and Kaylee, imagine the pain that they've been going through and just being in that limbo waiting for trial for 3 years. Needing a continuance at this late stage is surely just beyond the pale. And I'm glad that Judge Hippler is not going for this at all. All right, defendant has not established a continuance is necessary to conduct a more thorough life history investigation and identify necessary experts. Now, this I find really interesting. I find this this is the most interesting part. Defendant next argues he needs additional time to investigate and prepare mitigation evidence, which he contends is necessary to uphold his constitutional rights, particularly those under the 8th and 6th Amendments. Specifically, the defence team claims that to be effective, counsel must first conduct an exhaustive and comprehensive dive into defendant's life history. For additional mitigation evidence, analyse the information into a cohesive narrative for the jury and identify any additional behavioural, cultural, scientific and/or mental health experts that may be necessary to develop the mitigating presentation. Like Bryan Kohberger, right? He was 28 when he was arrested, right? So he's 30 now. But for 28 years, did this guy have such an interesting life? You know, was he really that complex that they need extra time to do this kind of life history review of him? Come on now. Come on now. That's just silly. That's silly talk. Despite having hired a mitigation team 2 years ago, Defence Counsel contends the recently discovered, and then here's where we get these redactions, that have raised red flags that defendant may have something. Defendant may have something. What, psychopathy? I don't know. So we've already learned that he's autistic and he's got obsessive compulsive issues. So what else is there? We don't know because it's been redacted. According to defendant's primary mitigation investigator, attorney such a body, even the name of this mitigation investigator has been redacted. Now, remember from footnote 1 on page 1, Judge Hippler said he was redacting the information that the defense had sent him ex parte, so for his eyes only. And he has done these redactions because, from, just to be cautious, he's not allowed the state the information that the defense gave him ex parte. So even the state doesn't know the defendant's primary mitigation investigator. Why? That's just shady, in my opinion. Why can the state not learn who the mitigation investigator is? That's just nuts. That's absolute nuts. Like, what's the big secret? Her team of 4 have been diligent in their investigation into defendant's life history. So they've had, for the last 2 years, they've had a team of 4 researching Bryan Kohberger's life history. So I think that's long enough. 2 years, and with 4 people, come on, he really can't be that complex, honestly. That's just silly. But there have been, and then a bunch of redactions. We believe, or she believes, that with time, she will be able to overcome these barriers. By what? We don't know. We don't know. So the most interesting part probably has been redacted. I just find this whole discussion interesting. Like, what are the defense playing at? Like a team of 4 for 2 years have been investigating Bryan Kohberger's life history. I mean, normally, right, you're right, they have interviews with the parents, they'll get school records, they'll get medical records, they'll do a psych eval, those kind of things, right? That's normal. But what else is there? What else is there to really look at? But anyway, Angie Baby's been a member for 23 months. One more month, and you get your OG badge. Your OG badge. Defendant has not demonstrated a continuance to accommodate further investigation is constitutionally required. The 8th Amendment requires that a capital defendant be allowed to present all relevant evidence in mitigation. And remember, this is not for the guilt phase. This is for the penalty phase if he is convicted, because it's a death penalty case. Okay, so jury must be allowed to consider all of a capital defendant's mitigating character evidence. In addition, a capital defendant has a 6th Amendment right to a fair trial and effective assistance of counsel in both the guilt and penalty phases of a capital case. As defendant points out, defense counsel is constitutionally required to conduct a thorough investigation in preparation for the penalty phase of a capital case. Now, again, they've had 4 people, a team of 4, doing this for 2 years. I think they should have done this by now, really. Presentation of some mitigation evidence, even if strong, is insufficient if other mitigation evidence is available upon reasonable investigation. The assertion that counsel needs the continuance to conduct an exhaustive and comprehensive dive into defendant's life history for additional mitigation evidence overstates the extent of his counsel's constitutional obligations. Counsel's investigations into mitigation evidence must be reasonable. The Idaho Supreme Court and the United States Supreme Court hold that defense counsel is not required to investigate a defendant's entire life in order to present constitutionally sufficient mitigation evidence. I mean, 28 years. He's just some regular dude who has, been pretty, I don't know, eccentric maybe, or peculiar maybe. There's going to be some interesting bits there for a psychologist or a psychiatrist to comment on. But he's been a student for most of his life. So, right, get your student records, get some interviews with, the people who taught him. And that's it. That's all you need. His school records. That's it. That's all. What more do you need? What are these red flags that have come up? It seems like you just in the realms of speculation here. Okay. All right. Wiggins and Smith says, we emphasize that Strickland does not require counsel to investigate every conceivable line of mitigating evidence, no matter how unlikely the effort would be to assist the defendant at sentencing. While defendant notes that the ABA guidelines for mitigation function of defense teams in death penalty cases urges counsel in death penalty cases to conduct an ongoing, exhaustive and independent investigation of every aspect of the client's character, history, records, and any circumstance of the offence to meet their constitutional obligations, courts look not to what is prudent or appropriate, but only what is constitutionally compelled. Rejecting argument that heightened procedural safeguards should be employed at a discovery in capital cases. Roe, a capital case, is instructive here. On post-conviction, Roe argued her counsel was deficient because they failed to perform an adequate investigation into Roe's background in search of mitigation evidence. Okay, I suspect, of course. Specifically, Roe argued counsel should have investigated her life from birth to the sentencing hearing, that counsel were deficient in presenting her mental health workup, The court rejected this claim, holding that counsel was not required to investigate Rowe's entire life in order to objectively and reasonably present Rowe's mitigation evidence. The court further noted the great lengths counsel underwent to investigate and present mitigating evidence from several of Rowe's friends, health and welfare records, letters from friends and family, and Veterans Administration records concerning Rowe's husband's previous injuries and the couple's relationship. So are we going to get Bryan Kohberger's birth records, like, how long his mother's labour was? Did he have the cord wrapped around his neck when he was born? Did he have a reduction in oxygen to his brain? What he was dropped on his head in the delivery room? What are we going to hear here? What are we going to hear? Come on now. Mandy, member for 31 months. I am on my way to 100k. Subscribe, everyone. Yeah, trying to get to 100,000 subscribers by the end of the year. I've got 6 months to do it. I think I can do it. I'm almost on 91k. So I've got just over 9k to go. I think I can do it. I know I can do it because I know that the majority of people who watch my videos are not actually subscribed to the channel. And if everybody who watched my videos subscribed, I'd be closer to 200k. It's insane. So please subscribe. If you watch my videos and you like them, or even if you just watch them just because it's a habit, just subscribe. It's completely free. No skin off your nose. It takes a second. All right. The investigation defendants experts has undertaken over the past 2+ years far exceeds that in Rowe, and in fact readily appears to satisfy the relevant ABA guidelines cited by defendant. It includes, so this is the stuff that we're going to get potentially from Bryan Kohberger's defense. Defendants' KPhD education records, including coursework, interviews, and correspondence. Defendants' mental health and medical records, including, we don't know, records relating to a childhood car accident. Defendants' employment records, mental health, education, employment records of defendants' sisters. Why? Why is his sisters why? Mental health records of his parents. Okay, all right. So if his parents had mental health problems while he was growing up, could that have affected him? Yeah, I guess. Okay, all right. Father's military records and social security records. Court records from multiple generations of Kohberger's family. Why? Why do we need court records from multiple generations of Kohberger's family? However interesting that's going to be. However interesting that's going to be. Why is that relevant? Like, if you're going back to his grandparents or his great-grandparents, unless he lived with them, unless it directly affected him while he was growing up, why is it relevant? If his parents were in and out of prison, maybe, okay, that's very relevant. But his grandparents or great-grandparents or uncles or whoever, how is it relevant? It's just very interesting, though. VA records and death certificates from maternal and paternal uncles. Again, why is that relevant unless you live with them? Multiple interviews with defendant and each immediate family member. Interviews of 2 of defendant's 4th grade teachers. 4th grade teachers. You're in year 4. How old are you when you're in year 4? Like 9, are you? 8 or 9? Why 4th grade teachers? What happened in his 4th grade? Ooh, it's all that exciting now. What happened in his 4th grade? Like, why have we not got 5th grade teachers or 3rd grade teachers? What is it about the 4th grade? Former boxing coach and psychologist who evaluated defendant in 2005. Interesting. Be interesting to see whether he was diagnosed with autism in 2005. Interviews with multiple members of defendant's extended family on maternal and paternal side. Interviews with defendant's professor and advisor at DeSales University. interview with defendant's former co-worker, interview with at least one family friend, and letters and jail calls between defendant and his family. Oh, release them, please. I want to hear the jail phone calls. You know, they've been releasing Stephen Stern's ones, so why can we not have Kohberger's? I know Stearns is in Florida, and Florida are very open about these things, but anyhow, okay. It is evident from the reports of defendants' mitigation experts, Dr. Orr, Dr. Ryan, and Dr. Brams, that they have developed an expansive understanding of defendants' family, environment, social development history, family history, both nuclear and extended, over multiple generations. Again, why is this family tree relevant? Unless he's living with them, unless they're directly influencing his life as a young person, how is his family tree, multiple generations, and what happened back in whenever, how is it relevant? Educational history and mental health and medical history. From this evidence, these experts have rendered several current diagnoses and identified other diagnoses for which defendant met criteria at some point in his life. Despite such an extensive investigation, defendant claims additional investigation is warranted to identify some things that we don't know. However, defendant has not established that such investigation constitutionally compelled, particularly given the extensive work already completed. Rather, the claimed need is based on unqualified speculation by, who we don't know. Defendant has not offered any declaration by any of his disclosed mitigation experts opining the same, nor has he pointed to anything that their expert reports would support blank speculation. As noted, a continuance of trial is not warranted to chase down mere speculation that potential evidence exists. Further, defendant has not set forth a plan for continued investigation, how much time it will take, what his team expects the investigation will reveal, why it's necessary to uphold his constitutional rights, and why these matters are only now being raised with the court. Additionally, assuming guilt is found, the penalty phase of the case will not begin until late October or early November. Thus, there remains significant time for blank, I'm assuming that's the investigator that can't be named, and her team to continue their investigation and to supplement expert disclosures if warranted. Absolutely, because even though the trial's beginning in August, this investigation team, you know, once the trial's ongoing, they're not going to be in the courtroom on the daily, are they? They're not going to be needed in court. They can just continue working. So they've actually got an additional 3 months after the time the trial begins. So how much more time do they need? They've already had 2 years, a team of 4. Anyhow, we don't get to see any of this. So we can't really get anything to grips with it. I mean, what's the point? Like, what's the point in giving speculation at defendant? It's simply that, speculation built on circumstances. You might as well have just blocked off the whole paragraph, because that doesn't tell us anything. But it does tell us that his own mitigation experts said something about ASD, so autistic spectrum disorder, OCD, and or ADHD are consistent with childhood trauma, and there is evidence of poverty, both generational and familial. Again, is poverty relevant? Only if Bryan Kohberger himself lived in poverty. Now, his parents live in a fair-sized house in Pennsylvania. Now, maybe they didn't always live in a fair-sized house, did they? When Bryan was little, live in a little shack in the woods, and and they had to go down to the stream to wash their clothes. Were they living in abject poverty? Did they literally have nothing? Did they have to, go and, I don't know, hunt a rabbit to have their breakfast? Were they living in that kind of environment? Or something similar? and then they managed to accrue some wealth and got a fair-sized house later on in life. Who knows? But if it's generational poverty from 2 generations back or 3 generations back, completely irrelevant, unless it's directly affected Bryan, whatever's happened to his family, in generations past, or his uncles or whoever, it's completely irrelevant. It's not for our concern, not for anyone's concern. Interesting though, but still, another paragraph redacted. Notably missing from blank declaration is any indication as to how she intends to confirm her suspicions. See, we're missing all this stuff. So the investigator, who cannot be named, has got suspicions. We need to know what these suspicions are. But because the defence has submitted this ex parte, the state can't know it. Therefore, we can't know it either. So how she intends to confirm her suspicions, or how long she expects it to take, be that months, years, or even decades. Dear God. Defendant has been subjected to multiple lengthy interviews by several different experts over the past 2 years. Based on the experts' reports viewed by this court, blank, don't know what that is. Defendant's family has likewise been extensively interviewed, and there has, so all these footnotes redacted. There's been no report that blank, none of defendants blank have raised the alarm that there's something really, 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 really interesting here, and we can't see it. So if he's convicted, is this going to be the bombshell of the penalty phase? Is it going to be the bombshell of the penalty phase? That, it's that sensitive that even the state can't see this before the trial. And for judges' eyes only. And you've got this tantalizing, right? Like they're dangling this carrot. They want us to taste the carrot, but we can't quite reach it. Oh dear. But none of these people have raised the alarm that, despite having the same information that blank relies upon, and all this redacted. Instead, it's an invitation for a perpetual continuance. More importantly, aside from the blank, all of this information has been available and documented in the record for months. Yet again, the defendant is only now moving for a continuance of further investigation into blank's unsupported suspicion, smacks of tactical gamesmanship and delay. Oof. Absent more compelling evidence that blank planned for, plan for uncovering it and a reasonable timeline to do so, there is no constitutional basis for further investigation, particularly on an open-ended basis with no plan to bring the matter home. And then this section, even the title is redacted. So I need to know. Even if it's really not that interesting, I need to know. It's like I want to like scratch off this black stuff. Like it's a scratch card. You have scratch cards where you live. So you go to the shop and buy a scratch card, and you scratch it off with like a penny or something, and you match it up and you win. You get like 3 of the same symbol and you win. You win your money back, or you might win a 50 quid or something. It's like I want to scratch it off. I want to see what's underneath. Like, no. Counsel's argument that more time is needed to investigate whether blank, likewise, squarely unsupported. All of that gone. Defendant has never moved for an extension to his disclosure deadline for penalty phase experts, so as to allow further opinions in this regard. Nevertheless, blank, who again is not even marginally qualified to opine, believes that there is evidence that blank and seeks additional time to unearth it. What does this person, this nameless person, need to unearth? Her support, which has not provided to the court. Again, not one of defendants' experts who had the same information blank as identified has submitted a declaration stated they may change their diagnosis based on further investigation. So it sounds like this is something to do with Bryan's psychological profile, given that his diagnoses that we know is autism, OCD, and ADHD. So it seems that this investigator wants to unearth further evidence that there's an additional or a different diagnosis. The diagnosis I'd like to see investigated is that of psychopathy. But that won't help his cause in any way, shape, or form. So what is it? What is it? Rather, it's based on blank speculation that further investigation might change blank. Such speculation is not grounds for a continuance. And again, loads redacted. Loads redacted. This shouldn't be happening. I understand why Judge Hippler has done this, because the defence has put all this stuff in ex parte. So, for the benefit of caution, for, any appellant issues, he's done this. But no, the defence should not be hiding this stuff from the state. The state has now got legitimate grounds to complain that there's stuff that's being withheld from them, that has been given to the judge ex parte, and now it's all redacted from the documents. And the state, quite rightly, should be able to know what this is all about. Not only is there a lack of support in the record for blank anticipation that more investigation into blank to change their minds, blank and her team, defence counsel, have known since November of 2024 that blank, neither defence team nor blank have articulated what efforts they have made, if any, since that time to understand the basis of blank. Further, they have not indicated what plan they have to obtain this information, if a continuance is granted, or how long it will take. In sum, defendant has not demonstrated that a continuance for further investigation into potential mitigation evidence is necessary to uphold his constitutional rights. The right to present mitigation evidence and the right to effective assistance of counsel does not necessitate an investigation of his entire history. They simply require that the investigation be reasonable. Whilst easily available mitigation evidence cannot be ignored, defendant's briefing demonstrates that evidence they are attempting to obtain is far from easily available and, in fact, may not even exist. Further, the evidence prompting the need for further investigation has blank been available for months and is only now that defendant seeks a continuance. This tactic seems geared towards achieving delay rather than a good faith effort to obtain meaningful mitigation evidence. I'm inclined to agree. Petty, member for 3 months. Thank you. All right. Moreover, defendant provides absolutely no plan for how further investigation will proceed, how it will be interviewed, or how long it will take. The Constitution does not demand, and this court is not willing to continue the trial indefinitely to allow the defence team to embark on a fishing expedition, pulling at every conceivable thread in defendant's familial tapestry. Oh, that's nice. Familial tapestry. Counsel's assertion that they will be better prepared with more time and more evidence is an assertion shared by every lawyer involved in a trial. At some point, and particularly after 2.5 years of investigation, the defence team must be satisfied with what they have, which is the case is extensive. In this case, is extensive. In addition, while the crime victim's rights to a timely disposition under Article 122 of the Idaho Constitution does not trump defendants' federal constitutional rights, they provide an additional justification for proceeding with trial as scheduled. For those reasons, a continuance is not warranted. Absolutely. Although, you know, the defendant has a right to a speedy trial if he demands it, and he waived that right to a speedy trial. Once he's waived that right, it doesn't mean to say that they can kick the can down the road for the next 10 years. And that doesn't mean anything like that, because you've got to think about the victims' families, that they have rights as well. And, you know, morally, if not legally, they have as much, they should have as much sway in the judge's mind. I mean, I know not legally, but certainly morally, you know, given that it is going to be 3 years in November. And given that the defense has been rigorous, there comes a time to say, no more. This stops now, and we get on with it. All right, a continuance is not warranted due to pretrial publicity. Defendant next seeks a continuance due to recent inflammatory pretrial publicity. On May 9th, 2025, approximately 3 months before trial is set to begin, Dateline NBC aired a 2-hour episode about this case. The episode included details and materials about the case which, if true, are not publicly available and which promotes a narrative of guilt. Defendant also advises that on July 9th, 2025, Amazon Prime Video is planning to release a 4-part docuseries about the homicides. And on July 14th, 2025, Prime author James Patterson is set to release a book he wrote about the same. But if they kick the can down the road for another 6 months, well, Amazon Prime, that's still going to be released. James Patterson's book's still going to be released. There might be another documentary that's been done as well. You know, the more time goes on, the more potential there is for people to have their eyes on these things. It's not like everybody's going to watch the Amazon Prime stuff and then no one else is going to watch it ever. The longer it goes on, the more people have got a chance to watch it. And the more chance there is that there's more documentaries and more books written. So, no, that's not grounds for a continuance at all. What it is grounds for is a very careful voir dire of the jurors, or potential jurors. And Judge Hippler is giving them 2 weeks to select a jury. So that's the way to deal with this issue, as I said previously. Defendant contends this media coverage is so close to trial it threatens his right to a fair trial and impartial jury, which can only be ameliorated by a continuance. In addition, defendant argues that a continuance is necessary to investigate the source of the leaks to the media and impose accountability. The court does not agree that either argument compels a continuance. So we've got some redactions here, but however, this does not mean the investigation into mitigation evidence has been unreasonable. Oh, that's mitigation. Okay. All right. Where are we at? Okay, next page. All right. Defendant's right to a fair trial is not denied by pretrial publicity, which is not likely to subside with time. Exactly. The 6th Amendment to the US Constitution affords all criminal defendants the fundamental right to a fair trial. This includes the right to have impartial jurors who know as little as possible about the case, decide the defendant's guilt based on materials admitted into evidence before them at the court proceedings, uninfluenced by extrajudicial statements. A trial judge has an affirmative duty to minimize the effects of pretrial publicity. In Shepard, relied upon by defendant, the United States Supreme Court recognized the adverse effect inflammatory publicity has on the ability to obtain an impartial jury and strongly urged trial courts to act quickly and forcefully in addressing such publicity. The court further advised that where there is a reasonable likelihood that prejudicial news prior to trial will prevent a fair trial, the judge should continue the case until the threat abates or transfer it to another county. So not so permeated with publicity, which is what has been done in this case already. It's been taken out of Latah County and sent to Ada County. So that's already been done. The statement from Shepard, however, must be read in context. The media coverage in that case is far different from that present here. In Shepard, news reporters extensively covered the story of Sam Shepard, who was accused of bludgeoning his pregnant wife to death. Oh, great guy. The court examined the extensive media fanfare surrounding the case, noting Shepherd was not granted a change of venue to a locale away from where the publicity originated, nor was his jury sequestered. For months, the virulent publicity about Shepherd and the murder had made the case notorious. Charges and counter-charges were aired in the news media besides those for which Shepherd was called to trial. In addition, only 3 months before trial, Shepherd was examined for more than 5 hours without counsel during a 3-day inquest, which ended in a public brawl. No! Oh, no! The inquest was televised live from a high school gymnasium, seating hundreds of people. Oh, where is this footage? We've got to watch this. If anybody can find it. If anybody can find it. So who's this? Sam Shepherd. What year? What year was this? Oh, 1966. 1966. It's unlikely to be on YouTube. It's unlikely to be on YouTube. But if anybody can find the footage in some kind of, it'll be in some television dungeon somewhere, like in a basement, filed away. Those old-fashioned tape recordings, the big reels. It'll be on one of them. Oh, I need to see it, though. If we can ever find that. That is so funny. So a 3-day inquest that ended in a public brawl in a high school gymnasium. Furthermore, the trial began 2 weeks before a hotly contested election at which both Chief Prosecutor Mahon and Judge Blithen were candidates for judges. So the Chief Prosecutor and the judge were both candidates in an election. Oh, come on now. Look, that's 1966. They were living in different times back then. So if Kohberger's counsel are relying on this highly strange case from 1966, they're struggling to find, they're struggling to find a more close to their issues case. So, no, come on now. Come on now. You can't use Shepherd. You can't use Shepherd from 1966 to make your point. No. The court found that there was no doubt that this deluge of publicity reached at least some of the jury. Given that when the jury was questioned for the only time, 2 jurors admitted in open court to hearing the highly inflammatory charge that a prison inmate claimed Shepherd was the father of that Shepherd was the father of her illegitimate child. So the jurors are listening to all of this stuff. Oh dear. Nevertheless, the trial judge rejected requests by defence counsel for the jurors to be asked whether they had read or heard specific prejudicial comments about the case. Further, the jurors were subjected to newspaper, radio and television coverage of the trial whilst not taking part in the proceedings, and were allowed to go their separate ways outside the courtroom without adequate direction not to read or listen to anything concerning the case. The judge gave suggestions and requests to the jurors at intervals during the trial to refrain from commenting upon the case, but the jurors were thrust into the role of celebrities by the judge's failure to insulate them from reporters and photographers. Bedlam reigned at the courthouse during the trial, and newsmen took over practically the entire courtroom. Oh, and this is the case that Ann Taylor believes can win her a continuance. Like, listen, a Dateline episode is nothing when you consider how it could have gone. That there could have been a public brawl in a gymnasium, an illegitimate child, and all the rest of it. An election. Different times. If she's using this as some kind of precedence, then she's not got a lot to go on, clearly. The court reversed Shepherd's murder conviction. Crucially, and rightly so, rightly so. Whether he did it or not, rightly so. That's terrible. Crucially, the court stated that although the pretrial publicity alone was not sufficient to warrant relief, when combined with the carnival atmosphere the press created at trial and the judge's inability or lack of desire to control courtroom proceedings, Shepherd's right to a fair trial were denied. Pretrial publicity, even pervasive adverse publicity, does not inevitably lead to an unfair trial. It doesn't. It's we know better now. We know better these days, to not allow public brawls and stuff and to control courtrooms better and to pick jurors better. If months of virulent pretrial media coverage was not enough to deny due process in Shepherd, it's certainly not enough in this case, where the media coverage has been far less pervasive. In addition, this court is employing the measures recommended in Shepherd. They've done it already to protect a defendant from prejudicial pretrial publicity, to wit, limiting the number of reporters in the courtroom during trial, insulating prospective witnesses from interviews with the media about their prospective testimony, making an effort to control the release of leads, information and gossip to the press by police officers, witnesses and counsel on both sides to avoid the disclosure of inaccurate and inadmissible information to the public. And also, the case has already been moved from Lator County to Ada County to better get a jury, or more easily to get a jury who don't know about this case. Ultimately, whether defendant can receive a fair trial depends on whether a fair and impartial jury can be seated. As the United States Supreme Court has said, to hold that the mere existence of any preconceived notion as to the guilt or innocence of an accused without more is sufficient to rebut the presumption of a prospective juror's impartiality would be to establish an impossible standard. Exactly. These days, with the internet and stuff, it's impossible to insulate every possible person from anything that they might hear. It's about getting the best jurors who don't have an opinion. The important thing is the ones who don't have an opinion on the case already. It's sufficient if the jurors can lay aside his impression or opinion and render a verdict based on the evidence presented in court. Accordingly, the Idaho Supreme Court has long recognized that trial courts can successfully select an impartial jury despite widespread publicity. In State versus Fetterly, a capital case, the Idaho Supreme Court disagreed with the defendant's claim that an extensive publicity prior to trial deprived him of the opportunity to be tried before an impartial jury. Because each jury was extensively questioned to determine the degree of their exposure to pretrial publicity, the court found the defendant's rights were preserved. In the defendant's subsequent habeas case, the Ninth Circuit examined at length the entire voir dire process and found no prejudice, even though on the day of jury selection, the case was covered on the front page of the local newspaper as well as on TV and radio. With the measures the court has already put in place to protect defendant against the pretrial media coverage and the court's carefully crafted jury selection process, there is no reason to think that an impartial jury cannot be selected through a searching and robust voir dire. In addition, while continuance may be appropriate if pretrial scrutiny is reasonably expected to fade with time, it is an ineffective tool where publicity is such that there is no reason to anticipate it would subside by any delay, which would not put off the trial indefinitely. I mean, look, you put the trial off for another year, and in a year's time, there's another documentary about it, and you're back to square one. It's ridiculous. In United States versus Marino Morales, the Court of Appeals for the First Circuit noted, the denial of a motion for an indefinite or substantial continuance predicated upon widespread adverse pretrial publicity about a defendant is all the more warranted when, as here, there is sound reason to believe that the defendant will continue to be a controversial, publicly invoking figure, and hence there is little assurance that the passage of time will result in an abatement or subsidence of critical publicity in the foreseeable future. Exactly. Because in a year's time, there might be another documentary, there might be another book, and it's more time for people to have seen the Dateline stuff and seeing the Amazon Prime docuseries, and for anything else that might come along in that time. The court observed that the Sixth Amendment guarantee of a speedy trial is one to which the government and society, as well as the accused, has a claim, and stated that society cannot be utterly deprived of the rights to prosecute and try someone for a crime within a reasonable time merely because of widespread community knowledge. Oh, God. In his reply, defendant argues that the allotted time is not sufficient for voir dire, given the vast media coverage. The court recognises that more time may be needed and has built in additional days for voir dire for this purpose. So even prepared to extend jury selection, the time that the jury selection will take. So Judge Hippler has done everything he needs to do. Honestly, honest to God. All right, where are we at here? See also these stuff here. Here, there's no assurance that the pretrial publicity will fade with time. The murders occurred over 2.5 years ago. The circumstances of the murders were provocative. 4 college students in a small Idaho college town were brutally stabbed to death by an unknown perpetrator. It was an immediate media sensation and garnered widespread attention that not only continues to persist, but continues to grow. 18 months ago, defendant moved for a change of venue from Latah County due in part to the extensive inflammatory pretrial publicity and allegations made about Mr. Kohberger to the public by media that will be admissible at trial. He argued that Latah County was not large enough to avoid the bias caused by the pervasive prejudicial publicity. Defendant's motion was granted, and as a result, the trial date was continued by approximately 10 weeks. And it was moved. It was moved. Those additional 10 weeks have not resulted in fading media attention. It has only given the media more time and opportunity to provide coverage to a public audience which is clamouring for answers. And continue the trial again, and it's just going to continue. It's just going to get hotter and hotter and hotter. The longer the public is made to sit and wait for the facts to come out at trial, the more time there is exactly for inflammatory, speculative stories, movies and books to circulate, and more time for prior ones to be rebroadcast. Exactly. Purchased, viewed and consumed by the public. Proceeding with trial as scheduled is likely will avoid negative consequences from future publicity. Thus, the court finds a continuance is not warranted based on the media coverage. Rather, careful and patient voir dire is prescribed. A continuance is not warranted to investigate the leak. Defendant also exerts that a continuance is necessary to accommodate the special prosecutor's investigation into the source of the leak to the media and to impose accountability. With regard to the Dateline episode, defendant points out that Dateline represented that the material came from sources close to the investigation. He noted that Patterson's upcoming book on the crime promise claims to be the most comprehensive narrative of the investigation and evidence to date, and is based on over 300 interviews, several individuals, including the victims' families and local law enforcement. He also notes that the Amazon Prime docuseries promises to be told in captivating, tense, and emotionally wrenching detail by only those involved in and affected by the crime. He argues that if any of the leaks came from witnesses the state intends to call from or others involved in the investigation, the information is Brady material because it would serve to impeach the leaker's credibility and may be exculpatory in nature. Well, it's not exculpatory. It's absolutely not exculpatory. Brady material, yes, but exculpatory, no. He adds that if the investigation reveals that other states' agents had information about the leaks but failed to disclose it, this omission would constitute a Brady violation. As noted, a continuance is not warranted where the information sought thereby is mere speculation. So back to Roe. Defendant's Brady argument is built on a house of speculative assumptions, an assumption that there was a leak by persons bound by the non-dissemination order, an assumption the leakers will be found, an assumption that the leakers were law enforcement, an assumption that the leakers or others who may be complicit will be testifying as government witnesses, and an assumption that those witnesses will likely be material. Such assumptions are not grounds for a continuance, particularly given that there is no guarantee if and when they will be confirmed or debunked. The trial cannot be held hostage indefinitely to the outcome of this investigation, particularly given the very significant chance of leakers may never be discovered. Thus, the court will not continue the trial pending the results of an investigation based on speculation that it will be successful and the hope that impeachment evidence may be uncovered as a result. Based on the foregoing, defendant's motion to continue is denied. It is so ordered. It is so ordered. Let's have a look. Oh, it's not a clickable link. So we've got James Patterson's book, The Idaho 4, An American Tragedy. Amazon Studios, Prime Video, debuts trailer for One Night in Idaho. College Murders. Again, can't click it. Pursuant to Brady versus Maryland, prosecutor has constitutional duty to disclose favourable evidence to the accused where such evidence is material, either to guilt or to punishment. This duty covers not only exculpatory material, but also information that could be used to impeach the credibility of key government witnesses. While the court observes in its documents and records on blah, 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 blah. The court has not made blah, blah, blah. All right, whatever. Okay, there we go. Boom. 20 pages. A lot of redactions in this section that is highly interesting to me. Look at these redactions. Look at that. Yeah. Love to know what all that's about. Love to know. Wouldn't you? Wouldn't you love to know? But there we are. So we're up to date on Idaho. Hate redactions. Well, Judge Hippler is doing it to be cautious, and I do like that. Let's not prejudice anybody in any way. If they want to give him stuff ex parte, I think the state has grounds to request seeing that information, though, given that it could be highly relevant to the penalty phase. I think they absolutely need to know what that information is all about. Oh, the investigation was properly handled, unlike Karen Reid. Dear God, yeah. I mean, no investigation's perfect. There's always going to be, some mistakes made, but it's whether those mistakes are so devastating that it means that either an innocent person is convicted or a guilty person is free. And in Karen Reid's case, fortunately, an innocent person wasn't convicted, but it's very, very unlikely. I'd be absolutely gobsmacked if anybody is ever arrested, let alone brought to justice for the murder of John O'Keefe. So, and that is about the lack of investigation in the time, in the days after, the way that things just weren't investigated. They just decided, oh, Karen Reid did it. There we go. Done and dusted. That's it. That's all. She was very lucky she got the jury she did. Yeah, she was very lucky. It could have been so much worse for Karen. Like Rick Allen. Could have been another Rick Allen. That's why I was really pessimistic throughout the whole trial. I was really pessimistic because I have residual Delphi trauma. So my faith in the justice system has been, it's been upped a little bit more confident now in jury trials. But still, this case remains to be seen, but it's going to be very, very, very interesting. I think we're going to hear a lot of information that we don't know. I think there's been a lot held back. And I'm open-minded. I do think, based on the information today, that they've got the right guy, but I'm open-minded. And if information comes out that I'm not convinced by, or information comes out that is exculpatory to Bryan, then I'll say so. I've no skin in the game whatsoever. I will say so. All right. So thank you all for joining me once again. And I will do a live stream going through Barry Morphew's indictment. I know it's a few days old now, but I will do that. Maybe tomorrow I'll do that. And then we're up to date on Morphew as well. So, yeah. Yeah, the Delphi PTSD, that's exactly what it is. Exactly what it is. Okay, thank you as always to the mods. And we had some members, long-term members here, 28 months, 44 months, that's a long time, 32 months, another 32 months, 23 months, 31 months, and 3 months. All good stuff. All right. Enjoy the rest of your day, and I shall see you tomorrow. I'll be back here with probably a recorded video in the morning, like my morning. And then I'll do the Barry live stream. I'll do the Barry live stream over on Michelle Walks, I think, because I've not been on Michelle Walks for a while. And I'm trying to kind of keep that up in the algorithm because people just don't get notified on that channel because I don't post on that channel enough for it to get in the algorithm. So I'll do the Barry indictment live stream over on Michelle Walks. It will be around the same time as today's. So like late afternoon, early evening, my time. Okay. All right. Until tomorrow. Bye, guys.